Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. Today we're going to talk about Virginia DUIs, and specifically, is it legal to, quote, sleep it off in your car before you drive home the next morning? Before we talk about that, though, I want to make sure you check out our Abrenio Law DUI practice page, and we've created an easy URL for you to find it. It's NovaDUICharge.com. That's Nova for Northern Virginia, so N-O-V-A, DUI for driving under the influence, and charge, obviously, so NovaDUICharge.com. There you can find out a bunch of articles that we've written, videos that we've shot, and we're continuing to add on to that library of information to help you become a more informed consumer about charges that either are facing you or a family member. So getting back to talking about sleeping it off in the vehicle, here's my advice. If you've drunk and you've decided to drink here in Northern Virginia, my recommendation is just download a simple app. It's called Lyft. You can also check out Uber. I think everybody knows what these things are, but they're low cost when it comes to the cost and potential danger that you present to yourself and other drivers on the road. If you had even, frankly, anything to drink and you decide you want to get back home or wherever you're going, just do yourself a favor and download those apps and have them ready and fired up to go, or of course have a designated driver for that night. But the way the law works here in Virginia is if you decide to sleep it off, it's not so clear whether or not you're going to be in the clear. In fact, there's a case that recently came out, I believe it's in 2017, it's Sarafin versus the Commonwealth that deals with this, and I'll put it in the if you watch this on YouTube, I'll put it on the show notes, but I've also written an article about it that it'll be easy to find on the website. But essentially in that case, the individual was found actually in the driveway of their own home. When discussed with law enforcement about what happened, he admits that he had a bunch to drink. He drove home. He then drank some more, and I guess that night perhaps he had a fight with a significant other or something. For whatever reason, he ended up in his own driveway, decides he's going to sleep it off in his car, has the key in the ignition but in the auxiliary position, so the lights are functioning, the music's functioning, all that, but it's not in the start position, it's not ready to go. And he decides to listen to some music, falls asleep, and then he wakes up to the knock of law enforcement. I guess a neighbor had called or somebody had called that caused law enforcement to go check on him. Law enforcement asks him about his drinking. He admits to it and ends up getting charged with DUI. Now, the common sense argument that was made to the trial court was, number one, Your Honor, he wasn't operating the vehicle. He wasn't driving. Number two, he wasn't on a highway. He wasn't on a Virginia road. He's on his own private driveway. How the heck can this be DUI? Well, it was, and the Supreme Court of Virginia upheld it. The reason being, driving under the influence in Virginia, in the Virginia Code, it's not simply driving your vehicle. It's not simply being behind the wheel and driving and hitting your brakes and hitting the gas. It's the term operating, which is given a much wider view. And really the case law, and Sarafin discusses it well, is really whether or not you have actual physical possession of the car. And the reason being, the court indicated in its concern is people when they're drunk, they can make unpredictable decisions. So let's say you decide that you're going to sleep it off, but you wake up at 2 a.m. and you're still drunk, and you decide, well, let me just try to drive home. I'm close enough. I can get it done, or wherever you're going to go. And so the court has indicated its concern for that. So they've expanded the definition of what operating a vehicle is. It's not just driving. The other surprising issue about this case is, again, it's not on the actual roadway where Sarafin was found in that case. And the court there said, under Virginia law, under the DUI statute, 18.2-266, that statute actually doesn't require that you be on a public highway or on a road here in Virginia to be drunk driving. And the way the court gets there is actually looks at the statutory interpretation, the actual specific text of 18.2-266. And I encourage you to go ahead and pull that statute up. pretty easy. If you're looking at this on our website, we've linked it all there, so it should be pretty easy to find. But if you look at that, it describes the prohibition of operating a vehicle while driving a vehicle, but it doesn't talk about on the highway, on a public highway, except when it specifically references other vehicles. For instance, mopeds, I think, is the specific one. So what the court said there is look, our legislature, the Virginia General Assembly, would have put in there a specific requirement of being on a roadway in order for there to be necessary to be a drunk driving conviction if it wanted to. It clearly didn't, and therefore, through that logic, there's no requirement of driving on a public highway or on a road here in Virginia to be guilty of a DUI in your car. Now, whether or not you agree with that logic, that's for your own personal opinion. Whether or not I agree with it as an attorney, as a citizen, as a driver here in Virginia, that's really beside the point, because as the law currently stands, the law is what it is. So if you're on a driveway, if you're in a parking lot, while there may be other concerns about what law enforcement can do, you can be convicted of a DUI by simply being in your vehicle. If you're in the auxiliary position, if the key's in ignition, I wouldn't go anywhere near that. Now, of course, there's questions concerning what if it's a keyless entry and a keyless start and all these kinds of things. I think the technology is still a bit beyond the law. I haven't yet seen a reported case, at least here in Virginia, about whether or not you have a keyless entry and keyless start and the intricacies and what factual circumstances may play there. But here's my rule. Don't get into litigation. Don't make it to where you have to have a court find out and decide for you. Don't do everything you can to avoid the charge in the first place. So if you're buzzed, if you had something to drink and you know you shouldn't be driving, or you think you shouldn't be driving, you probably shouldn't be driving, just pull up that app. It makes it very easy. The technology's great, and you'll get to where you're going. Have a designated driver. Don't risk it, because being charged with a crime is way more expensive than that app, using that app that night. I can tell you, if you injure yourself or you injure somebody else, or you severely, if you kill somebody, the cost of that is going to be endless. And it's not just from a dollar value, but from the emotional standpoint of the harm that you cause the community, as well as yourself having lived through the trauma of having hurt somebody, having hurt yourself, or killed somebody. So do yourself a favor. If you have any other questions about Virginia DUI law, Virginia criminal law, or Virginia personal injury law, you can check us out at www.abreniolaw.com. Again, the DUI practice page, we've created an easy URL. It's novaduicharge.com. You can also give us a call, 703-570-4180. We look forward to hearing from you. And if you have any other questions, make sure to reach out to us. Again, we're constantly adding to our informational library to help people make good decisions about their case and who to hire as an attorney. So suggestions are always welcome. We're constantly updating this information. Thanks a lot, and we look forward to hearing from you.